Test, Dalton. Good. Chair Griner.
Yes, sir.
All right. Good morning. Welcome to this public hearing of the House Finance Committee. And I'd like to start by asking our senior committee legislative assistant to call the roll.
Good
Lori.
morning. Chairman Samuelson,
Here.
Sapita Freites,
We'll have several people on leave, but we'll also have some folks online. So on leave.
Dave Deloso,
On leave.
Rep Fiedler,
Here.
Frail,
Here, online.
Gallagher,
Here.
Kenyatta,
On leave.
McNeil,
Online.
Mursky,
Here virtually.
Rab,
On leave.
Scott,
On leave. Virtually present online.
Smith Waddell,
On leave.
Waxman,
Here.
Webster,
Present online.
Chairman Griner,
Present virtually.
Bernstein,
On leave.
Brown,
Here. Online.
Fritz,
On leave.
Jones,
On leave.
Here online.
Oh, my apologies.
Kephart,
Here.
Kutz,
On leave.
Mako,
On leave.
Here.
Oh, my.
McCreary,
On leave.
Rader,
On leave.
and Rossi.
Present online.
15 present, other members on leave today. And some of the ones who are on leave will be joining us online during our hearing. So I'd like to start. We have one bill to consider today. It's my intention to bring this bill up before the committee next week when we have a voting meeting on October 1st. So I wanted to give the opportunity for our committee members to discuss the bill. It is a bill introduced by Representative Briggs of Montgomery County, and it is House Bill 1994, dealing with the process that we have before the Board of Finance and Revenue for tax appeals. So I'd like to recognize Representative Tim Briggs, the chair of the Judiciary Committee. Pleasure to have you on the Finance Committee today.
Great, thank you, Chairman. I was a member of the Finance Committee my first few terms and enjoyed the work. And thank you for having a conversation on House Bill 1994, and Chairman Griner for joining us, and all the members for joining us. This was a bill that I started working on just under a year ago through conversations with the Pennsylvania Institute of Certified Public Accountants. To try to make a taxpayer-friendly bill to address two main things. Since then, there's been a lot of conversations, a lot of meetings, a lot of great engagement, and I anticipate being able to, after today's hearing, put together a good, solid amendment to make this bill even better. It does two simple things. One is it allows late appeals to be accepted up to a 60-day grace period if a good cause is shown and appreciated. And also, it creates a formal settlement process, which there is a current process that compromise can be entered. But I feel like it could really be bolstered and enhanced more to try to come up with arrangements. We have experts that are going to be sharing more experience on this. But the taxpayer, the entity, coming up with an agreed to settlement process rather than forcing them to go to Commonwealth Court. I think it would be advantageous for the Commonwealth, definitely helpful for the taxpayers. And I do appreciate Chair Samuelson being involved with this. His staff, Mark Foreman and Shannon, have really been great to help me understand it and to be part of all these great conversations we've had. I'm not going to get too into the weeds on it. I think we have great testifiers, but I am going to stay to participate. Over the years, we get calls from taxpayers who, based on whatever reason, feel like they're getting jammed up or not getting treated fairly. So I think this is a good way to be more taxpayer friendly. Thank you, Chairman.
Thank you. Thank you, Representative Briggs. I want to give the opportunity to the committee members. I know we have a lot of great testimony lined up from Department of Revenue.
I do want to mention this. This is worked with Senator Hutchinson in the Senate. He has a companion legislation, Senate Bill 1051, which started out at the same point. I think in the next day or so, the amendment we'll put together will make House Bill 1994 something a lot of us can be proud to support.
And I appreciate that you've been working on an amendment to the language that we're looking at today. That amendment, obviously, if we call this bill up on Tuesday, October 1st, the amendment we'd finalize that amendment by Monday, September 30th.
Understood. Thank you.
Gotcha.
Thank you, Chairman.
I do want to give the opportunity to Chair Greiner and other members of the committee to ask some really, really tough questions of Representative Briggs. But before we get to the testifiers, we will have Department of Revenue, we're going to have the State Treasury, and we're going to have the CPA organization testifying before us. Does anybody have a question for Representative Briggs? Chair Greiner.
I'm a co-sponsor of the bill, so I appreciate Representative Briggs' efforts, and of course, I guess, like you said, Senator Hutchinson. I think, hopefully, with the amendment and everything, we can, have like I said, have a really good bill where all the parties work together. I think it's something that needs to be done. Obviously, I've worked in public practice too at the accounting firm, and I think I think it's a real positive step in the right direction, and hopefully, when it's all finished, all the parties will be happy, and we can move forward. And just like I said, I want to thank the maker of the bill for his efforts, and glad to support him in this endeavor.
Thank you, Chairman.
Thank you, Chair Greiner.
Welcome.
We'll have opportunities for questions throughout the meeting. If any member has a question right now, I'll call on you, but if not, we'll go right to the Department of Revenue. Thank you. Appreciate that. Now I'm going to call up a tax expert in the state of Pennsylvania. I'm talking about Amy Gill, who is the Deputy Secretary for Tax Policy for Department of Revenue and has been with the department, I think, 27 years. So it's a pleasure to have you here, and I'd like to call on Amy Gill for her testimony.
Excuse me, Chairman Samuelson, Chairman Greiner, and members of the committee. Thank you for the opportunity to meet with you today. As Representative Samuelson said, I'm Amy Gill, Deputy Secretary for Tax Policy, and on behalf of Secretary Pat Brown, I would like to take a few minutes. I'm going to outline the current appeals process. So the appeals process in Pennsylvania has 4 stages: the Board of Appeals, the Board of Finance and Revenue, Commonwealth Court, and the Pennsylvania Supreme Court. Each step in the appeals process has distinct procedures and characteristics that help to ensure that due process is provided to taxpayers both effectively and efficiently. The goal of the tax appeals process should be to resolve tax issues accurately at the lowest level possible. Additionally, any proposed changes to one level of the tax appeal process should be considered in the context of the collective impact on the tax appeal system, as a change in one level will inherently have effects on all levels in the system. So delving first into the first level of appeal, which is the Board of Appeals, for calendar year 2023, the Board of Appeals, or as I'm going to call it, BOA, had almost 36,000 appeals with $2.5 billion at issue. BOA resolved 92% of the cases brought before it. So in other words, no additional action was required by the taxpayer. The case was resolved. As opposed to higher levels of appeal, which are adversarial public proceedings, BOA is a non-adversarial confidential proceeding. The non-adversarial nature at BOA allows the board to do some hand-holding to assist individual taxpayers in navigating our appeal process. This high level of customer service, as reflected in our surveys, has led to over 92%, again, of all tax appeals being resolved annually at BOA. The confidentiality that BOA provides is also appreciated by taxpayers. Furthermore, BOA is focused on continually improving its processes and accessibility. A few examples: short videos on our website to explain what to expect in the tax appeals process and what to expect in our compromise process. The board has added technology solutions like optical character recognition to reduce data entry errors and increase capacity. We have a data analytics program which helps us to react quickly to increases in appeals and to allocate resources as needed. This has led to a decrease in the appeal turnaround time from a high of 125 days to our current turnaround time of 78 days in 2024. The board has also introduced a new taxpayer-friendly petition form and will
Excuse me for 1 minute. We have a lot of virtual participation. We have to make sure that we're reconnected, so I'm going to pause the meeting for just a second until we get back online.
if it's okay, I think I'm going to step back a little farther. I'm not sure when we lost. There's a few points I want to get across. Is that
Thank
okay?
you. We're back. We're having some connectivity problems online. We are back online. I'm going to call on Amy Gill, and she's going to repeat a little bit of the last couple minutes of her testimony. Thank you.
Thank you. So the Board of Appeals is the first level. For calendar year 2023, BOA had nearly 36,000 appeals with $2.5 billion at issue. BOA resolved 92% of all cases brought before it. So in other words, no additional actions were needed by the taxpayer to close their appeal. As opposed to higher levels of appeal, which are adversarial public proceedings, the Board of Appeals is a non-adversarial confidential proceeding. The non-adversarial nature of BOA allows the board to do some hand-holding to assist individual taxpayers in navigating our appeal process. This high level of customer service, as reflected in the results of our customer service survey, has led to over 92% of all tax appeals are resolved annually at BOA. The confidentiality that BOA provides is also appreciated by taxpayers. Furthermore, BOA is focused on continually improving its processes and accessibility. A few examples include short videos on our website to explain what is to expect in both the tax appeals process and the compromise process. The board has added technology solutions like optical character recognition to reduce data entry errors and increase capacity, as well as a data analytics program that helps the board react quickly to increases in appeals and to allocate resources where they are needed. This has led to a decrease in appeal turnaround times at BOA from a high of 125 days to a current turnaround of 78 days in 2024. The board has also introduced a new taxpayer-friendly petition form and will introduce a new online petition center in early 2025 that will allow taxpayers to actually track their appeals through the appeal process. So in 2013, BOA was granted the authority to compromise tax appeals. From 2013 to 2023, BOA has granted over $1 billion in relief in the form of compromise. Of those taxpayers who were interested in a compromise, BOA was able to reach agreeable compromise terms in 85% of those situations. Next, I'll talk about BF&R level with just some basic statistics. The appeals at BF&R have declined from a high of 5,482 in 2018 to just over 3,000 in 2023. At the BOA level, the Board of Appeals level, only 38% of taxpayers have a tax professional, such as a CPA or attorney, assisting them with their appeal. Many of these self-represented taxpayers are looking to fix simple tax errors or omissions. At BF&R, 71% of taxpayers are represented by a tax professional and are frequently raising sophisticated tax arguments that may challenge DOR's legal interpretation of a statute or even contest the constitutionality of the statute itself. So, while it is true that under current law, BF&R has no authority to direct a settlement process, there is a process already in place at BF&R to facilitate compromises on tax appeals. BF&R already has compromise authority if the petitioner and DOR agree or if there is doubt as to the liability, and to promote effective tax administration. We commend BF&R for clearly publicizing the existing compromise process on its website in a handout called The Board Encourages Compromises. As a result of BF&R's active and public support for the existing compromise process, in 2024 year-to-date, BF&R has used the existing process to resolve 300 tax appeals out of 1,808 total tax appeals resolved. So this represents 16% of the cases closed at BF&R. It's also important to note that no mediation or settlement process at either level will prevent some cases from going to Commonwealth Court. So I want to thank you again for the opportunity to testify, and I can answer any questions the committee may have.
Thank you. I would call on any member of the committee if they'd like to ask Amy Gill a question. I'm going to start with two. You did say that the number of cases that went from the Board of Appeals in the Department of Revenue to the Board of Finance and Revenue has declined from 5,400 5 years ago to about 3,000 last year. What would you say were some of the reasons for that decline?
I'm going to look to Ryan Froman for a second, if you don't mind.
Come on up, Ryan. And
Okay. Thanks, Ryan. So Ryan is suggesting, and I agree, that it would be a result of aggressive compromise settlements at BOA, and also a lot of hand-holding and really trying to resolve issues and not letting them get to the next level. And some of that may not be a formal compromise process, but instead are looking and saying, okay, a simple a change here will make this tax issue go away. If there's money on account, there's something we can do. So I agree with Ryan. I think that would be the reason for the decline.
Okay. And my last question, you said 1,808 cases this year. We're 9 months into the year. Sounds like, are we on pace for about 3,000 or even a little bit less for the number of cases that are going to the Board
Yes.
of Finance and Revenue?
Yeah, I think that would work out mathematically to being probably about a little under 3,000 if the
Okay.
current trend continues.
All right. Thank you. I'm going to call on if Chair Greiner has any questions for Amy Gill, or and we have another rep. Chair Greiner, I have one other member who has a question right now. I can call on you last. I will call on Mike Jones, Representative Mike Jones first, and then any other member who has a question. Representative Jones?
Thank you, Chairman. And it sounds like you guys are doing a lot of good work there at Revenue. Appreciate that. Just a bit of a curiosity question, I guess. The 92% that you referenced that are settled kind of in the first phase there, is that typically sort of and I don't know if there's a couple, I'm not looking for specific statistics, but maybe a couple general buckets. Is that typically taxpayer error where they made what I'll call an honest mistake? Or do you kind of track that maybe there are a couple things in the tax code that generate a lot of those appeals because maybe they're a little more confusing than they need to be? Or, now put differently, are they resolved in the taxpayer's favor, or is it typically the taxpayer made a mistake, they acknowledge it, fix it, and move on?
It's both. At our level, 42% of appeals are personal income tax, and often those are a combination of taxpayer error, a notice sent out, and a discovery later on that the taxpayer did maybe have money in a different account. We check for that, but it's not perfect. 28% of the appeals were sales and use tax. Those sometimes are requests for refunds from taxpayers looking for a refund on sales tax they may have paid and did not owe. And finally, almost 13% are property tax and rent rebate. And I think this is where we especially try to help the taxpayer navigate the PTRR, because as Representative Samuelson and all of you know, it is a complex process. Unfortunately, they have to show their income, they have to show their property tax. Sometimes they are denied for their income's too high, they're not of the proper age. So there's a lot of 12%, 13% of PTRR, and we really spend time on that, trying to help the taxpayer understand the issue at hand.
Thank you. Appreciate your work on the PTRR. My office, we're up over 960 that we've done this year.
Thank you.
I know Representative Marla Brown, who's online, I think maybe the busiest office in the state on the PTRR, but we thank you for the opportunity to work with you on some of those situations. Representative Jones, did you have a follow-up question?
No, that was all. Thank you, Chairman.
Thank you. Any other member who have a question for Amy Gill? And Chair Greiner, if you'd like to ask a question, or I can.
I just want to I thank her for her testimony and thank her for being here. And like I said, just the whole process and everything. I'm glad that we're addressing it and taking care of it. And it's great to have somebody, have a deputy secretary come today to participate in this, because it's important. So thank you.
Thank you. Appreciate your testimony. And
Yes, I'd like to thank you again and Representative Briggs for the opportunity, and we've really enjoyed working on this bill, so thank you.
next, I'm going to call on behalf of the Pennsylvania Treasury Department, I'm going to call on the Chief Counsel, Christopher Craig. Thank you. Chief Counsel Craig, the floor is yours.
Thank you, Chairman Samuelson. Thank you, Chairman Greiner, members of the committee, for inviting myself to share with you the perspective of Pennsylvania Treasury on the legislation currently before you, House Bill 1994. I don't have planned remarks. but I thought maybe some context would be useful, and I can make myself available for questions during today's hearing or even follow up prior to any particular vote. I think, let me make it clear, this bill has nothing to do with the Department of Revenue. We don't touch upon, suggest any changes at all to any of the procedures before the Board of Appeals that's within the Department of Revenue. Rather, this bill is exclusively related to the procedures before the Board of Finance and Revenue. Now, it's important to understand that the Board of Finance and Revenue, in that four-step appeal process that you heard about, is the first opportunity for any taxpayer to have an independent review of their tax dispute. When I say independent, I mean an entity other than the Department of Revenue. 10 years ago, the Pennsylvania General Assembly amended the fiscal code to reform the Board of Finance and Revenue. And in so doing, they created a 3-member board that is completely independent from the Department of Revenue. So when we say and use words like adversarial proceeding, it means that the Department of Revenue has to make their case in front of an independent, neutral arbiter, in this case, the Board of Finance and Revenue. It's composed of 3 members, 2 that are nominated by the governor and confirmed by the Senate, and 1 individual that is appointed by the state treasurer that serves as the chair. That person is Jackie Cook, who's been there approximately 10 plus years as the chairperson of the Board of Finance and Revenue. The Board of Finance and Revenue, the best way to think of it is a quasi-judicial administrative tribunal. They conduct their proceedings in an open manner like a court would, though taxpayer information is kept confidential, and the proceeding is adversarial in the sense that both parties, the taxpayer and the Department of Revenue, are on equal footing, and they present their case before the 3 members. Significantly, Board of Finance and Revenue statutorily required to resolve all appeals within 6 months. That, as you can imagine, puts a lot of pressure on the board, but they have met that pressure consistently, without fail, at least over the last 14 plus years that I'm aware of. We have a little bit different statistics than what you've heard. Approximately over the last 5 years, the average number of appeals that hit the Board of Finance and Revenue is about 4,200. That takes into account the COVID years in which it was lower because of less filings, but it doesn't pick out just 1 year. It is a fairly steady case. It's between high 3,000s, low 4,000s. Only about 13% of the appeals that are filed with the Board of Finance and Revenue are ultimately resolved by a settlement. But let me be clear, the grand authority that you heard about for settlement authority at Board of Finance and Revenue is that they can approve it, period. That's it. All they can do is approve something that is presented to them. They can't initiate it. They can't tell the parties, I think you should meet together in the room next door. They can't oversee it. They can't mandate a conversation. They don't have the ability to appoint a hearing officer. Many of the cases that then leave the Board of Finance and Revenue are settled on the steps of Commonwealth Court. By that time, both the taxpayer and Department of Revenue have incurred costs, sometimes substantial costs, with outside counsel. We think at least 500 cases each year could benefit from a mediated settlement process. Now let me go back and explain. House Bill 1994 does 2 simple things. Number 1, it grants the board the authority to permit a late filed appeal to be heard by the board and resolved, if good cause is shown. Now that phrase is important because that's used in just about every court in Pennsylvania, that if there is a late filed appeal, but there are circumstances beyond the control of the appellant, they can demonstrate to the court that there's good cause for them to grant their appeal, and there's no prejudice to the other party, in this case, the Commonwealth. That's it. That's all the first portion does. Now, there's been discussions about amending that in order to change that open-ended filing period, or at least petition period to request a late filed appeal, to about 90 days. That would resolve most, but not all, of the late filed appeals. The other concern that we would have in a change to that is that one of the changes being circulated limits that to only personal income tax appeals. That's it. It doesn't cover sales tax, doesn't cover corporate tax, doesn't cover realty transfer taxes or other taxes. Now, the bulk of these late filed appeals would involve personal income taxes, but not all. And make no mistake, your colleagues in the House and in the Senate routinely call the Department of Treasury and say, I have a constituent. They got really jammed up. They missed the filing date by X number of days. Can you please help them out and consider it? And we can't. Under the statute, we have no authority to grant jurisdiction to consider a late filed appeal. That means that that taxpayer whose first opportunity to hear their case independently is now lost. This involves the person that's diagnosed with Alzheimer's and doesn't understand the mail coming in. The people that had to be away for a medical emergency or other problem and couldn't open up their mail in time and receive the notice from the Department of Revenue. Somebody that puts in a change of address form and that's not processed and they don't get in time the notice from the Department of Revenue. It's not a criticism of the Department of Revenue. It's a recognition of human reality that problems arise and all we're seeking for the BFNR is the same authority that just about every court in the Commonwealth has to consider a late filed appeal if good cause is shown. The second simple change in this law is to create an independent mediated process to promote settlements. Now, this is significant because the board, as I indicated earlier, does not have the ability to tell parties, I think you should talk and resolve this. You're missing this document, or you should consider this piece of evidence, or we think this is easily resolved because there's a mathematical error. So this would allow the board to tell both parties to sit down with the mediator. It doesn't impose a settlement. The Department of Revenue or the taxpayer is perfectly able and capable under the proposed legislation to say, I don't support this settlement. I'm not going to adhere to it. We're going to litigate it. Fine. But what this allows is BFNR to hit the pause button on that 6-month period of time and say, parties, I want you to talk. I want you to meet with this hearing officer, and I want you to try to see if you can work out a settlement, period. And I got to say, that is pretty routine in Commonwealth Court where a lot of these cases could end up being ultimately in that 4-step process that you heard about earlier. That's it. That is the essence of the bill. It's 2 very pro-consumer, pro-taxpayer initiatives that empowers this board to try to resolve cases without a taxpayer having to incur additional costs. This is probably not going to be terribly impactful for an entity like Comcast. Comcast has very sophisticated attorneys. They have very sophisticated tax preparers. This is really aimed towards Bob down the street who's having trouble with his taxes and doesn't know how to resolve it. I think it's great that parties are given an opportunity to settle before the Department of Revenue. But unless that individual knows to pick up the phone and initiate that, they are going to miss the settlement process. They won't have that opportunity, or whether right or wrong, they don't feel like they're getting a fair shake out of the Department of Revenue. BFNR is the opportunity for them to at least have their case heard independently. I can stop there. I think I've kind of outlined the general thrust of the bill, what we're trying to accomplish at BFNR. Fundamentally, this isn't a criticism of the Department of Revenue. This is all about empowering the Board of Finance and Revenue with the tools to be a little bit more responsive to your constituents.
Thank you, Christopher Craig. I'll open it up to questions from the members of the committee. I'll start with 2. You said out of the approximately 4,000 cases, you said 13% are currently come to a settlement, come to a compromise. You think there might be 500 more of those 4,000 cases, another 12% that could be
Potentially.
possibly come to a settlement under this proposed process.
That's correct.
So then it would end up being about a quarter of all the cases. The rest would be headed for Commonwealth Court, as is.
It could be.
Yeah.
We all in state government, particularly, at Treasury, get caught up in a data debate. Is it 12%? Is it 20%? Is it 10%? Can I come to you with complete candor and tell you, in all honesty, yeah, we're definitely going to get 500? No, I don't. We haven't been down this road before. But I think it's all it is an authority to the board so that they can do that. And even if it's, let's say it's only 200 cases, that's still 200 taxpayers that don't have to hire an attorney, that don't have to incur additional costs, that the Commonwealth can get their money faster.
Okay. Thank you. And I do realize the bill, as written, was introduced by Representative Briggs in January, and Representative Briggs has been engaged in a lot of negotiation and discussion with the Department of Revenue and Department of Treasury since then. So we will have an amendment next week when this bill comes before the committee. I do want to note for the members that on page 2, it references the good cause for late filed appeals. That language, as it currently stands, is on the top of page 2. And on the bottom of page 2 and following, we have discussion about the settlement officer and also the settlement process that this bill proposes. I do want to ask Mr. Craig, Attorney Craig, the settlement officer, who would you envision that person would be that's not currently a position that's involved in the BF&R?
Correct. So the bill defines that individual that can be either an employee of Treasury or by contract. They would either have to be an attorney or a licensed attorney or licensed CPA with experience in Pennsylvania state taxation matters. The department would have the authority to put them under contract, pay them per hour, and allow them strictly to be a hearing office, in essence, a mediator to try to resolve the case.
And that person would be selected by the 3-member Board of
That's
Finance and Revenue.
That is correct. Pursuant to the criteria and qualifications that Representative Briggs has included in 1994.
Okay. Thank you. I do want to open it up to any other member who has a question for Chief Counsel Craig. Chair Greiner, you got to go either first or last or anytime you want.
Yeah, well, like I said, I just appreciate the testimony, very informative, and hopefully, like I said before, hopefully any kind of amendment can be agreed to among all parties, and that there's yeah, like I said, the devil's in the details in the language. But once again, just like the prior testifier, I appreciate him coming in today and providing more, additional insight just to clarify everything. So thank you. Still hoping moving forward we can accomplish something next week.
Thank you, Chair. Thank you, Chair Greiner from Lancaster County. At this time, no other members are having a question, so I will move on to our next testifier. But I'll ask Chief Counsel Craig to stick around. Maybe at the end, when we have member discussion, there'll be further questions.
Thank you very much, Mr. Chairman. And again, I just offer the opportunity, even beyond today's hearing, if anyone has any questions, there's additional information we can provide. Our legislative office is extremely responsive, and we'd be happy to help. Thank you.
Thank you. And for our fourth and final testifier, we have someone on behalf of the Pennsylvania Institute of CPAs. In the room, we have Peter Calcara, the Executive Director of the Pennsylvania Institute of CPAs, but online is our testifier. I believe we have James Brower Jr., a CPA and a partner in Marks Paneth, and chair of the Pennsylvania Institute of CPA State Taxation Steering Committee. And I see online James Brower Jr., and I welcome
Good morning.
your testimony.
Good morning. I hope everybody can hear me.
Yes.
Can you? Okay, good. All right, good. The computer's working and you can hear my voice. All right, I want to thank Chairman Samuelson and Greiner and members of the Pennsylvania House Finance Committee for having me today to present testimony to you. My name is James Brower. I am a managing director with CBIZ Marks Paneth in Philadelphia. I specialize in federal, state, and local tax matters. I have over 30 years of experience in those areas. I'm also a longtime member of the Pennsylvania Institute of Certified Public Accountants and serve as the chairman of that body's State Tax Steering Committee, which represents a broad segment of state thought leaders across the Commonwealth who would who advocate for fair and effective tax policy and providing strategic leadership on state and local taxation issues. I'm here before you today to voice our support for House Bill 1994 and its companion bill in the Senate, Senate Bill 1051. What these bills do is build on the success of Act 52 of 2013, which Mr. Craig explained reconstituted the Board of Finance and Revenue from a 6-member board from various areas of state government down to 3 members, 2 of whom are not nominated by the governor, confirmed by the Senate, and a 3rd member who was appointed by the state treasurer's office. So we're just taking what was done about 11 years ago and hoping to further expand on that and make Pennsylvania's tax appeals process hopefully a little bit better. Although House Bill 1994 does provide for some relief for late filed applications or late filed petitions, the centerpiece of these bills is the establishment of a formal settlement conference process that taxpayers and the Department of Revenue can avail themselves of after a taxpayer files an appeal with the Board of Finance and Revenue. And just to go back to what Ms. Gill explained earlier in her testimony, there are 4 levels of appeal for most tax disputes in the Commonwealth. That first level is with the Board of Appeals. Imagine you have an individual taxpayer, they file their tax return, it gets processed by the department, they find a problem with it. Perhaps the department thinks there was unreported income, or the taxpayers are requesting a refund that the department, for whatever reason, doesn't believe they're entitled to. The department communicates their findings to the taxpayer, either a denial of refund or a notice of assessment. Or if it's a business tax, it could be many times sales and use tax. And many businesses have sales and use tax responsibilities. They get audited. There's an assessment made. They wind up at the first level of appeals with the Board of Appeals. Board of Appeals is held within the Department of Revenue, so it's not a completely impartial body. As Ms. Gill explained, last year the board heard over 30,000 petitions or appeals petitions. The vast majority of those are settled at the Board of Appeals level. So I think that's good. The Board of Appeals is doing its job there. Over 90% of cases taken to the Board of Appeals don't go further beyond that body. However, there are certain cases that, for whatever reason, the taxpayer believes that the decision of the Board of Appeals was not favorable to them. So there is a second level of appeals that exists in the Commonwealth. That is the Board of Finance and Revenue, which, unlike the Board of Appeals, Finance and Revenue sits outside of the Department of Revenue. So it is perceived, and it is a more impartial body than the Board of Appeals itself. And here, it's a bit of a more formal process. Taxpayers can have a hearing. Those hearings are recorded. They're available online. And if the board has 6 months to render a decision, that can be extended for another 6 months if the parties agree to. But a decision is rendered, a written decision is issued. That's also published online, although generally the numbers are redacted, but you still see these cases come up. Now they're not precedential, but it is a bit of a more formalized process than the Board of Appeals itself. Now beyond the Board of Appeals, beyond the Board of Finance and Revenue, or BF&R as we like to call it, taxpayers could then appeal to Commonwealth Court, and a lot of cases that get out of BF&R go up to Commonwealth Court, especially larger tax cases. But when you go to Commonwealth Court, it's a more expensive and time-consuming process. While an individual taxpayer might try to represent themselves, Commonwealth Court, it's probably not the best thing to do. So you need to hire attorneys, and but it's only at the Commonwealth Court level where the taxpayer and the department can really entertain in settlement negotiations. On the current process, that while there is a compromise process that taxpayers can avail themselves of, those settlement negotiations generally happen, as Mr. Craig said, on the steps of Commonwealth Court. And what this bill would do was enable both the taxpayer and the Department of Revenue to move that settlement process down from Commonwealth Court down to the Board of Finance and Revenue level. So under the bill, once a taxpayer files their petition, they then have 30 days to request a settlement conference to the board. The board would take that request. They would ask the Department of Revenue if they agree to enter into a settlement conference with the taxpayer. The Department of Revenue doesn't have to agree to that. If they think their case is strong enough, very strong, they could say, no, we don't think we need a settlement conference. We're quite happy with our position on this. And the case would go to the BF&R as normal. But if both the taxpayer and the board agree, a settlement officer would be appointed to take the case. That settlement officer must be a licensed attorney or a licensed CPA who has extensive knowledge of Pennsylvania's tax laws. While they are an employee of the Treasury, that is it. They are otherwise an impartial party. They're not an employee of the Department of Revenue or of the Board of Finance or Revenue. They're a Treasury employee because they're getting a paycheck from the Treasury, but otherwise they are going to be an impartial. I won't say arbiter. They're a mediator in the process here. So tax laws are complicated. They can be complicated, and you can have areas where the law isn't black and white; it's quite gray. And right now there is no mechanism for parties to enter into those negotiations, enter into that negotiation process to settle a case before Commonwealth Court. This bill, if enacted, would allow for that process to start at a lower level. So once that case is filed with BF&R, again, the taxpayer would have 30 days to request a settlement conference. Presuming Revenue agrees to that, the settlement officer is appointed. They bring the parties together for a meeting, and within 30 days, they are to either come up with a settlement with the settlement officer acting as a mediator between the parties, encouraging them to come to a number. That mediator will share their thoughts with the parties to let them, and this will be without the other party's knowledge, perhaps say, hey, I don't think you have a good case, or I think you have a really good case, or I think maybe they'll throw out some numbers to again, the goal here is to initiate a settlement between the parties without going further up to Commonwealth Court. If the parties agree to a settlement number, hey, that's great. They'll write up a settlement. They'll bring it to the Board of Finance and Revenue. Presumably, Board of Finance and Revenue is going to accept that settlement, and we're done at that point. The taxpayer owes money. The Commonwealth gets their money. If the taxpayer is owed money, the Commonwealth will send them a refund for what the Commonwealth owes them. If both parties can't come to an agreement, though, the process ends, and we go back to where we were, going to the 3-member panel of the Board of Finance and Revenue. They'll hear the case. They'll render their decision. If the taxpayer doesn't like it, the taxpayer can then go to Commonwealth Court. Maybe they'll get a better deal dealing with the AG's office or somebody, but at least this is an alternative to that process. As a state and local tax practitioner, I don't just deal with taxes here in Pennsylvania. I deal with them with surrounding states and some far-flung states in the country. I can tell you that other states have a process like this. The purpose of it is to encourage the taxpayer and the taxing authority to come to an agreement, work out a settlement without clogging up the courts with tax cases. We don't, now, under current law, the Board of Finance and Revenue has 6 months to render a decision. That can be extended for another process as be a those
Stand by.
deadlines.
Can
So the
we?
purpose here is to and
Are you still connected to us?
participate. Am
Can you hear me, Mr. Brower?
I here?
Yeah, we just had a little trouble in the last 15 seconds hearing you.
Oh, okay.
You're still
All right,
connected?
hopefully you hear me now.
There we are. There you are.
I am.
Okay.
Okay. you can
Proceed.
hear me?
Yep.
Okay, thank you. All right. So what this what House Bill 1994 does is just sets forth an alternative path at the BFNR level for the taxpayer and the department to settle their arguments with each other before a settlement officer. They don't. This is not arbitration. The settlement officer does not have the authority to force a settlement on either party or to render a decision. Their job is to get a meeting of the minds together to come to an agreement and settle the case, which the BFNR would then presumably accept, and we're done at that point. If they can't agree, the case just proceeds on its normal, and perhaps you go to BFNR. So I believe, let's see, what else was I going to mention here? Yeah, this is an informal process. We think this is a structured but adaptable process which aims to efficiently resolve disputes between taxpayers and the Department of Revenue without unnecessarily extending the existing statutory period for the Board of Finance and Revenue to render an appeal. There are strict timelines in place here. The taxpayer has 30 days to request a settlement conference. Once that conference occurs, there's a 30-day period to wrap things up and either bring a settlement to the board or an indication that the parties can't agree, and we'll then let the board render their decision. As far as costs go, there's been an estimate put out there that the cost of implementing this process would be $500,000. Presumably, there would also be costs to pay the wages of your settlement officers. I don't know how much that would be, but they would be on the payroll of Treasury. As far as who would likely participate in this process, this would be a lot of small taxpayers, individuals aggrieved by decisions of the Department of Revenue and the Board of Appeals, but would also be large businesses as well. To be a whole, I could see all sorts of taxpayers electing into this alternative route. Again, provided that the Department of Revenue also agrees to go along with the settlement process, which we would hope they would in most cases. So, in conclusion, both House Bill 1994 and Senate Bill 1051, they promote a more flexible, efficient, and fair tax dispute resolution process by introducing a settlement conference option, which offers a constructive alternative to full litigation in Commonwealth Court. The Pennsylvania Institute of CPAs strongly encourages the committee to consider this legislation as it provides a valuable alternative mechanism to expedite and simplify tax dispute resolution in the Commonwealth. Thank you.
Thank you very much, Mr. Brower, for your testimony. I do want to give the opportunity to the members of the committee and also Chair Greiner to ask questions. I will start with a couple. I appreciate during your testimony you talked about the fact that the process that's envisioned in Representative Briggs's legislation, at the front end, both parties would have to agree to enter the settlement process that's outlined in House Bill 1994. And at the end, if there's a settlement, on page 9 of the bill, it talks about if there is a settlement that both parties agree to, that would be implemented, and there's before the board. And if there's not an agreement, it would go back to the process that's currently in place under state law. So as I understand Representative Briggs's legislation, both parties would have to agree to enter the settlement process, and obviously both parties would have to agree to an ultimate settlement if there is one. I do want to ask Mr. Brower, what types of clients are you representing, your firm, before the Board of Finance and Revenue? Are we talking about personal income taxpayer clients, small businesses, limited sole proprietorships, or are we talking about large corporations? What kind of clients do you represent?
Sure, good question. So of the 30,000 appeals filed with the Board of Appeals last year, probably 20 to 30 of those were mine. I represent all sorts of taxpayers. So I represent individuals and businesses. Individuals, it's typically personal income tax. I have one case now regarding use tax. Just filed a petition with the Board of Finance and Revenue on that one on Monday of this week. I've represented large businesses for sales tax before, and corporate income tax as well. So in my practice, I handle a wide variety of businesses and individual taxpayers.
And you did say you work with some other states. Are you talking about neighboring states that might have a similar process to what's being proposed here?
Yeah, I do a lot of practice. I do a lot of work in New York State, and in that state they have what's called the Bureau of Conciliation Mediation Services, and it's what they do there is, I believe, very similar to what House Bill 1994 does. You have sort of an independent conciliator or mediator come in to sit down with the taxpayer and the New York Department of Taxation and Finance to hammer out an agreement and come to an agreement. And they will issue a recommendation and try to encourage a settlement between the parties. So that's how they do things up there. Across the river from me in Jersey, you have the Conference and Appeals Branch, which it's part of the Division of Taxation. So maybe it's more like the Board of Appeals here, although they do tend to consider hazards of litigation. And they do try to settle things. Don't always get your way there, but at least many times you feel at least you got a fair shake.
In New York, did you say consolation or consultation?
Consolation.
Okay.
Bureau of Conciliation, CONCILATION, and Mediation Services.
Okay. Thank you. Where any other member would have questions, they'd be certainly in order to ask them. I don't think I have anybody online raising their hand right now. If not, I will call on Chair Greiner if you have any questions or comments for Mr. Brower.
Like I said, just appreciate the PICPA being there and providing input. And like I said, all the testifiers today. I think it's like I said, hopefully we start making something that's a little bit more taxpayer friendly for the consumer. It's like you said, it'll be for the little guy. It's not going to be for the Comcasts of the world, and to at least get the process moving forward. And like I said, appreciate just coming full circle. Appreciate Representative Briggs. I know he's been working on this a lot. There's a lot of give and take, talking to Treasury, Revenue. You got to work with the accountants, and hopefully we can come up with a product that that has some teeth to it, that makes sense moving forward, not too watered down. And I know, I guess Senator Hutchinson's working with it over in the Senate. So I just appreciate you, Mr. Chairman, for having a hearing on it. I thought it was very informative, and I think it provided more information, and I think it was a help to all of us on the committee. So thank you.
Thank you, Chair Keith Greiner. At this point in the hearing, where we've had our 4 testifiers, we have an opportunity for member discussion. If any other member of the committee would like to have any comments, speak now. We also obviously will have discussion next Tuesday, October 1st, when this bill would come up before our committee. Any other member would like to have a comment? If not, I would like to thank our 4 testifiers, Representative Briggs, Amy Gill, our Deputy Secretary for Tax Policy, Department of Revenue, Christopher Craig, Chief Counsel of the Treasury Department, and also James Brower on behalf of the Pennsylvania Institute of CPAs. Thank you, Representative Briggs, for bringing this before our committee. We will see you next Tuesday. And with that, this public hearing is adjourned.